All right, I think we're ready to get started, everybody. Welcome to the Hicks Thomas CLE presentation for today. This is part of a series of CLEs that we like to put on. Well, at the end of this presentation, I'll be giving you a heads up about next month's CLE presentation. But today, our topic is going to be a 2023 year in review. I'm going to be presenting along with I'm going to be presenting today along with my associate Mariana Jantz. I'm a partner here at Hicks Thomas. I'm an appellate specialist. I've been here for longer than I want to remember. I've been practicing longer than 25 years. Mariana is one of our newest associates who splits time between our Houston and Beaumont offices, and she'll tell you a few things about herself whenever she gets up. But I'd like to jump into today's topic. Well, there's two general topics that we're going to be covering here today. One is new Texas courts that the Texas legislature created last year. And the other one is key cases decided by the Texas Supreme Court last year that may be relevant to your business. We're not going to cover any of the uniquely government cases or some of these politically charged cases that came up over the last year. But we are going to cover a select group of cases that could be relevant to your business going forward. First, the new courts, and this is a topic that's been talked about quite a bit the last 6 months or so since the legislation passed. And I'm going to cover the high points for both of these in case you're not familiar with these new courts. The first point is we don't have them yet. They go into effect in September. And so there's a lot of planning and, adoption of rules and working out all the logistics of it that are going on between now and then. So we don't have them yet, but the plan is to have these courts in place by September 1st. And there's two different courts. There's the business court, and then there's a new 15th Court of Appeals. The business court is a specialty court. It's like a state district court, except it has a jurisdiction that's specific to business cases, and particularly internal affairs type business cases that involve corporate governance, shareholder derivative suits, claims for breach of fiduciary duty, claims for violations of securities regulations, and actions under the Texas Business Organizations Code. It's the court for these types of cases. The court has the same powers as any other district court. It's just that the subject matter is limited. One thing that's notable about this jurisdiction is the court does not have supplemental jurisdiction unless the parties agree. If another claim, say, for instance, say you have a big shareholder fight and there's a defamation claim that gets asserted, that would not, even though that arises out of the same set of circumstances, the court would not have supplemental jurisdiction to consider that claim. The parties could agree to it, but without barring an agreement, that claim would have to be filed in a different court. These business courts will have a amount and controversy requirement if it involves a private company. If it involves a private company, there has to be at least $5 million in controversy. And in a case such as a declaratory judgment action, that amount in controversy can be established based on the value of the interests at stake. And there's actually existing case law for doing that. For example, in a removal federal cases context based on diversity, where there's an amount in controversy, you don't necessarily have to have 5 million in damages asserted, but you do have to have 5 million or the value of 5 million in controversy. With the dispute involving a public company, there is no minimum amount in controversy, so those claims will be within the jurisdiction of the business court. Here's a very interesting element of this, and this is something that's particularly noteworthy for in-house counsel. For large transactions that are valued at more than $10 million, the parties can stipulate to jurisdiction in the business court for those disputes. So that might just be an ordinary contract claim or fraud claim or whatever. If it involves just a transaction of over $10 million, not $10 million, if the parties agree, much like a forum selection clause or venue clause, then the business court would have jurisdiction. Now, there is one caveat to that, and I'll get to that in a moment. One of the elements of these business courts that is the most different from going to a regular state district court is the judiciary. The judges will not be elected in popular elections the way they are for district courts or courts of appeals now. The plan is for them to be appointed by the governor for 2-year terms, and then every 2 years they're up for reappointment by the governor, but they serve at the governor's discretion, and their term is only 2 years. The qualifications for these jurists is also different from a typical district court. They have to be at least 35 years old, and for a district court judge, the minimum is 25. They have to have at least 10 years of relevant experience involving complex business matters. For a district court judge, they just need 8 years of general legal experience. They have to be a resident in the division for at least 5 years. For a district judge, it's 2 years. And they have to have no history of disciplinary action against them. The organization of these courts is also unique. The entire state is considered one district. So it's one district that includes every county in the state. That one district then is divided into 11 divisions. And initially, only 5 of the divisions will be created with judges. And those are divisions that cover the major metropolitan areas in Texas. So Houston, Dallas, Fort Worth, Austin, San Antonio. And each of those divisions would have 2 business court judges. For the other 6 divisions, the plan is to eventually adopt those later, and because they're less populated areas, they would only have 1 judge. The procedures in the business court will be essentially the same as in a state district court. They will have some special rules for filing cases in that court, dismissing cases out of that court when they don't have jurisdiction, removing cases from other courts into business court when they do have jurisdiction, and the like. There are committees working on those rules now. They haven't been officially adopted yet, but they're in the works, heading towards a September startup. And trials, each division may cover a large geographic area, but if there's a venue statute that applies, or if you have a forum selection agreement that specifies a particular city or county, those will be honored for purposes of trial. Okay, on to the 15th Court of Appeals. Now we have 14 Court of Appeals now. This is a new one. It's and has justices. They're not appointed, they are elected, but they're elected statewide, much like the Supreme Court or the Court of Criminal Appeals. So they're different from the other intermediate courts of appeals, where they are voted in by the voters in an area of like several counties, like the 1st and 14th here in Houston. They're elected by a 10-county area. The justices for the 15th Court of Appeals will be elected statewide, just like the Supreme Court. Initially, there'll just be 3 judges. They'll be appointed by the governor later this year, and then they will stand for election in the next general election, which would be 2026. And then the plan is to add 2 more justices to have a total of 5. The other 2 would be appointed in 2027, and they'd stand for election in 2028. Now, the 15th Court of Appeals is not like the other courts of appeals. They don't have jurisdiction over everything within their purview. They have a specific list of cases that types of cases in courts from which they have appellate jurisdiction. One is, of course, these new business courts that we were just talking about. Another is appeals from any actions by or against the state or state agencies. But that excludes kind of the routine everyday litigation that the state's involved in. So there's a long list of exceptions in the statute for what is and what is not covered by the 15th Court of Appeals, but essentially it's targeting sort of the unique, one of a kind type of cases that are challenging some kind of statute or agency action or state action. And then they also get appeals challenging the constitutionality of state action or state statute where the Attorney General has intervened. So very specific jurisdiction that's limited to these categories. Now, these courts are not without controversy. And that's part of the caveat I was getting to. Business court judges, obviously, they're not elected and they have 2-year terms. The Texas Constitution requires district court judges to be elected to 4-year terms. And there's an argument that the appointment for 2-year terms violates the Constitution. And so that can't stand up. And they serve at the pleasure of the governor. They're up for reappointment every 2 years. An individual case could go on much longer than that. So there's some concern that political forces could force a judge out. They just didn't like some of their rulings. And the 15th Court of Appeals essentially takes a lot of cases away from the Austin Court of Appeals, because a lot of those cases they're filed in Travis County. They go to the Austin Court of Appeals. They will now go to the 15th Court of Appeals, whose justices are not elected from the Austin area, but are elected statewide. And, as you probably know, all of our statewide elected office holders are from one party. So there's some people that are going to complain that that's some sort of a power grab. The other thing to keep in mind is when the legislature adopted the statutes that create these courts, they were expecting legal challenges. They even built in a provision saying that the legal challenges they're expecting will go straight to the Texas Supreme Court. So stay tuned to see what happens there. There's a chance there will be litigation over that, and there's some chance that some of these provisions might be thrown out. And that's something to keep in mind. In particular, if you're inclined to include a forum selection clause specifying the business court in a purchase and sale agreement or a merger agreement or some other major transactional agreement, because there is some chance that they may not come about as planned. So if you were inclined to include that, which, all things being equal, it would be a good idea, because these business courts could be a real game changer for this type of litigation. But if you're inclined to do that, I would include a contingency in the event they don't come about as anticipated. So that's the new courts. Next, we're going to talk about Texas Supreme Court cases decided last year that you need to know about that may be relevant to your business. And for that, I'll turn it over to Mariana.
Great. Thank you, Stephen. As Stephen said, my name is Mariana Jantz. I'm a little too tall for this camera frame. I joined the firm about 6 months ago following a clerkship on the Court of Appeals for the 8th Circuit. Before that, I was clerking on the Eastern District of Texas, and I also worked in New York City for a law firm. So as Stephen mentioned, we went through and culled what we think are some of the most important cases for your businesses that the Supreme Court issued in 2023. And we'll start with some cases on arbitration. In Leonard Homes of Texas versus Whiteley, can I move that so it's out of the... So while we do that, in the case of Leonard Homes versus Whiteley, a gentleman named Cody Isaacson purchased a home from Leonard Homes. The purchase and sale agreement included an arbitration provision and incorporated a warranty that also included an arbitration provision. He sold the home to Miss Whiteley, who soon thereafter filed suit for construction defects. So the issue before the court here is whether a subsequent purchaser of a home is going to be bound to arbitrate her claims against the builder in a residential construction case. The trial court initially stayed the case for arbitration, but when the arbitrator found in favor of the builder, the trial court vacated the award, and the Court of Appeals affirmed. So the Supreme Court says, yes, because Ms. Whitley's claims are premised on the existence of the purchase and sale agreement, she is bound to arbitrate under the doctrine of direct benefits estoppel. The biggest takeaways from this case are the court really solidifying its position in favor of arbitration and enforcing arbitration agreements through direct benefits estoppel, even for non-signatories. In this case, as we'll see next, extends to factually related personal injury claims. These next two cases I'm going to discuss at the same time because they're factually and legally quite similar. In the Ha case, Mr. Ha signed a purchase and sale agreement for a home that contained an arbitration provision. After discovering a mold problem, he filed suit for breach of contract and other claims against the builder. He was joined in that case by his wife and minor children, who originally asserted breach of contract claims and then amended to only assert personal injury and other non-contractual claims. The Skufka case is essentially the same, except in that case, the minor children did not, their claims were not differentiated from the parents. So in other words, all of the plaintiffs in that case asserted breach of contract claims. The issue here is similar to the Leonard case. Are non-signatory parties going to be compelled to arbitrate along with the signatory parties? The trial courts in both cases denied the motion to compel for the non-signatories to the purchase and sale agreement, but did grant the motion to compel for the signatories, and the Court of Appeals affirmed in both cases. The Supreme Court said that litigants who sue based on a contract subject themselves to that contract's term, and non-signatories cannot avoid arbitration, even though, as in the Ha case, they amended their petitions to allege only tort or other non-contractual claims. And this is notable. It's a big win for developers and builders, and it places developers and builders in a solid position to enforce arbitration agreements against virtually all possible litigants. And it provides consistency across the board in the dispute resolution processes. And in the past, plaintiffs' lawyers would try to get around arbitration provisions like they did in this case, and the court has finally ended that practice. Our last arbitration case is Total Energies versus MP Gulf of Mexico. The parties in this case were signed various agreements between the two of them. One was a cost-sharing agreement and one was a system operating agreement. The system operating agreement contained an arbitration clause that importantly incorporated the AAA rules of commercial arbitration. Total sued after a dispute arose under the cost-sharing agreement, and MP then initiated arbitration. The trial court granted the motion to stay arbitration, and the Court of Appeals reversed. The Supreme Court held that, yes, parties, if you incorporate the AAA commercial rules into a contract, this constitutes a clear and unmistakable agreement that the arbitrator is going to decide arbitrability. And this is an agreement with the majority of other courts on this matter. Parties still maintain the contractual freedom to delegate arbitrability however they choose, but it's important to be specific in those carve-outs, because if just a general incorporation of the rules is going to, the courts are going to interpret that as delegating arbitrability to the arbitrator. All right, now moving on to attorney-client privilege. In the University of Texas system versus Franklin Center, University of Texas became concerned about allegations of improper admissions practices. They hired an outside firm called Kroll to conduct an investigation. After the investigation was complete, the Franklin Center sued under the Public Information Act to try and get the documents that were used in this report and created in this report. The trial court found that the documents were privileged, and the Court of Appeals reversed and ordered that they be produced. Now, the key part of this case is the language in the agreement between the University of Texas and Kroll, which defines the scope of work as basically an evaluation of the conduct of UT officials as it relates to admission services and whether their conduct is beyond reproach. And what is noticeable about this language is it doesn't explicitly refer to Kroll as a legal representative or as performing legal services. It does note that the final report is due to general counsel. The issue in this case is whether Kroll is covered by the attorney-client privilege, and the Supreme Court says that yes, in this case they are. Franklin Center had argued that because the language of the engagement letter did not explicitly state that they were engaged for legal services, that is not the decisive factor in deciding whether or not they are covered by attorney-client privilege. The court held that to qualify as a lawyer's representative, assisting in the rendition of professional legal services must be a significant purpose. And then in applying that test, the court held in this case that the investigation was privileged because the investigation was to be conducted under the direction of the general counsel. All communications in the final report were to be submitted to the general counsel, and the consultant was required to maintain confidentiality. So in this case, the court is telling us that substance governs over form in privilege issues, and this was kind of a close call because the Court of Appeals and 2 Supreme Court justices would have ruled to disclose these documents. And so in best practices moving forward to ensure that this doesn't come up is to include in your engagement agreement explicitly that the purpose is to provide legal services, the company's legal department will direct and oversee the work, and the consultant was engaged by the company's legal counsel. Now we'll turn to labor and employment cases. Our first case, Cameron International Corporation versus Martinez. Cameron hired an oil field worker named Mr. Mueller to do a short period of contracting work out on one of their rural oil fields. Mr. Mueller finished his period of work. His boss asked him to hang around with the anticipation of more work coming up. His boss also invited him to dinner in town. After Mr. Mueller drove to dinner in town, he stopped on the way back to the oil field to pick up some personal groceries. He proceeded onto the oil field, and he was involved in a car collision that resulted in 2 fatalities. The decedents, estates, and survivors sued Cameron and Mr. Mueller for negligence. And the key issue in this case is whether the employer can be held liable via vicarious liability. The trial court granted summary judgment for the employer, and the Court of Appeals reversed. The Supreme Court found that Cameron couldn't be held liable in this case, and the Court of Appeals interpreted the special mission doctrine too broadly in applying it to this personal errand. Under the coming and going rule, an employee does not act within the course and scope of their employment during their commute to and from work, but Texas law allows an exception for special missions that are directed by the employer, and a personal trip for groceries does not fall into this exception. In this case, even if the task indirectly supports the employer, it's not going to be considered within the course and scope of employment. The plaintiffs tried to argue that because Mueller would share some of the groceries he got with his coworkers and would use them on the job site, that they should be held liable, but the court maintained its narrow scope of vicarious liability. In Texas Tech versus Nihei, Dr. Nihei was a resident at Texas Tech University Health Science Center, and she was terminated essentially for not being able to perform the functions of her job. She sued, claiming that she was discriminated against because Texas Tech perceived her as being morbidly obese. The trial court denied Texas Tech's motion for summary judgment, and the Court of Appeals affirmed. And so the issue in this case is simple: is morbid obesity an impairment under the Texas Commission on Human Rights Act? The court says in this case, no. The plain language requires a disability to be a mental or physical impairment, which requires an underlying physiological condition, and weight is merely a physical characteristic. The court leaves open that obesity can be considered a disability if it qualifies as an impairment, which means out of the range of normal, and it occurs because of an underlying condition. And another important thing from this case is that even if the medical community generally considers a condition to be a medical disorder, that's not going to be controlling under the Texas Commission on Human Rights Act. Our last employment case is a retaliation case. Thompson was a nurse at Scott and White Memorial Hospital. She received 2 disciplinary reprimands, and on her second reprimand, she was warned that future reprimands could result in termination. She gets a 3rd reprimand for violating HIPAA. She was concerned about a minor patient. She contacted the minor patient school nurse, and the parents complained. At the same time, she filed a report with Child Protective Services. She sued, claiming retaliation for her protected activity. The trial court granted summary judgment, and the Court of Appeals reversed. In this case, the Supreme Court found that the Court of Appeals incorrectly reversed the entry of summary judgment. The court looked at the statute in the family code that made this conduct protected activity and found that it was similar to other statutes that required a but-for causation. So it looked at whether the employer in this case could show that Nurse Thompson would have been fired even if she had not engaged in the protected activity, and the court found that the hospital sustained this burden. So this raises the threshold for plaintiffs in this type of retaliation case to prove but-for causation, and adds a little bit of protection for employers who will not be found reliable if they can show that the adverse employment action would have occurred regardless. Point Energy Partners versus MRC Permian is what appears to be the Supreme Court's first force majeure case that it decided on the merits. To suspend termination of its oil and gas lease, MRC Permian was required to begin drilling a new well by a certain deadline. Due to a scheduling error, they had scheduled this drilling to begin weeks after this deadline. Once they realized their mistake, they tried to invoke the force majeure clause and say that their drilling was delayed because of an incident with another well that delayed their operation and extended to this well. Point Energy Partners disagreed, said that they were taking the lease, and the parties cross-sued for declaratory judgment. The trial court found that the force majeure clause did not perpetuate MRC's release, and the Court of Appeals found a fact issue and reversed. The Supreme Court found that the force majeure clause in this case does not extend to a scheduling error, basically. The language, lest these operations are delayed by an event of force majeure, does not refer to something that was scheduled to commence after the deadline. Our big takeaways from the first force majeure case decided on the merits: the court's going to strictly construe force majeure clauses and require a causal nexus. For personal jurisdiction, in LG Kim versus Morgan, plaintiff alleged that he was injured after a lithium-ion battery that he used to charge his e-cigarettes exploded in his pocket. He sued the South Korean manufacturer and the American distributor. The defendants argued that they only sold and distributed the battery to industrial manufacturers and not individuals like the plaintiff. So is a non-resident defendant's purposeful contact sufficiently related to the plaintiff's product's liability claim to support the exercise of specific jurisdiction? The trial court denied the defendant's special appearances and the Court of Appeals affirmed. The court says yes, if a non-resident seeks a benefit in Texas, specific personal jurisdiction will attach, even if the plaintiff is not a member of the targeted consumer market. So this case, we learned, don't mess with Texas. This is one of several cases, this term, finding personal jurisdiction over non-residents. And it's important to look not only at the defendant's contacts with a particular market segment, but Texas as a whole. These next two cases were consolidated on appeal, and they arise out of the Volkswagen emission scandal, where Volkswagen rigged some of its vehicles to perform better in emissions testing in labs than they performed out on the road. The state of Texas sued the European manufacturers, and in an interlocutory appeal, the Court of Appeals found that the state lacked jurisdiction. And there's two issues in this case. The first is whether the manufacturers purposely availed themselves, even though they used intermediaries and distributors. And secondly, whether purposeful availment is lacking because the manufacturers targeted not just Texas, but vehicles throughout the nation. The court says yes to the first question and no to the second. The German manufacturers could reasonably anticipate being held into Texas court, even though they used distributors and intermediaries. And for the second question, the court found that simply because you target other forums, that does not diminish your contacts with Texas. And so our big takeaway from this case, controlling the distribution scheme is a plus factor, and actions taken through intermediaries are not going to provide a haven from the jurisdiction of a Texas court. In Finley Resources versus Headington Royalty, Finley owned the shallow rights on a tract of land in Loving County, Texas, and Headington owned the deep well rights, which were contingent on how much the shallow wells produced. Headington became concerned that Finley wasn't producing enough. They sent a demand letter. Around this time, Finley sold its shallow rights to Petro Canyon, and Petro Canyon also obtained a top lease on the tract of land. Headington learned about this. Headington purchased the rights from Petro Canyon, and they executed a release. And the language of the release covers Petro Canyon affiliates, officers, directors, shareholders, employees, agents, predecessors, and representatives. So the issue in this case is whether predecessors included predecessors in title, such as Finley, or only predecessor entities. And that little red thing there is Loving County, Texas, population of 64 people. And so the trial court granted summary judgment for Finley, and the Court of Appeals reversed. So the court here looks at not only the technical meaning of the word, because there's potentially broad meanings, but the court also looks at the context as a whole and the grammatical and syntactic structure, and decides that predecessors is limited to corporate predecessors or entity predecessors. The court also looks at the fact that this word predecessors is in a list with all of these other terms that are part of the corporate structure. And so though courts can consider context when construing the meaning of words in a contract like they did in this case, the context cannot change the language but explain it. Another important thing to learn from this case is that when you're executing releases, that you tie, if your goal is to tie the predecessors not only to the parties, then you also need to make sure that you tie them to the parties, but also the assets, and to make sure that you're releasing exactly what you want to release, because the court will construe that narrowly. In Ray First Reserve Management, this case arises out of a 2019 series of explosions that occurred at a plant in Port Neches owned by TPC. A lot of people were injured. It was the day before Thanksgiving. Tens of thousands of people had to be evacuated from their homes. When the original defendant, TPC, became apparent they were going bankrupt, the plaintiffs then tried to sue First Reserve Management, which is the private equity parent company of TPC. The trial court denied the defendant's motion to dismiss under Rule 91A, and the Court of Appeals denied mandamus relief. The Supreme Court found that it was error to refuse mandamus relief, and found that just because First Reserve Management appointed members of the board of director to TPC, that's not going to be enough to support a negligence claim. Negligent undertaking liability requires proof of affirmative course of action. Omission isn't going to be enough, and neither is simply doing something like appointing members of the board of directors, because that is within the normal behavior of a private equity management company. It's not enough to extend tort liability. Last case I'm going to talk about is McLean Champions versus Houston Baseball Partners. In 2011, Houston Baseball Partners bought the Astros from McLean Champions. They also bought the Astros rights in sort of a regional broadcasting network. And shortly after the purchase, that broadcasting network collapsed, and Houston Baseball sued McLean Champions, saying that they made material misrepresentations in promoting that broadcasting network. The McLean Champions moved to dismiss under the Texas Citizens Participation Act. The trial court denied, and the appellate court confirmed or affirmed. So the Supreme Court found that the Texas Citizens Participation Act does not apply in this case. The Houston Baseball Partners lawsuit was not based on or in response to McLean Champions' exercise of free speech or right of association. The communications underlying the suit were not made in connection with a matter of public concern. They weren't relevant to the public audience when they were made, and so just because they became somewhat relevant to the audience afterwards, that's not enough to fall under the umbrella of the Texas Citizens Participation Act. The challenge communications were private business negotiations and an arm's length transaction, and that is not enough to relate to a government proceeding or a matter of public concern such that the TCP will cover it. With that, I'm going to, and this, so under the newer amendments to this TCPA, this case looks at those and illustrates how they've narrowed its application. So with that, I'm going to turn it back over to Stephen to talk about a few more cases.
Right, just a few more cases, one insurance case and a couple of oil and gas cases. This is the insurance case, ExxonMobil versus National Union Fire Insurance Company. The issue in this case was whether an umbrella policy that had been procured by one of Exxon's contractors covered Exxon in a personal injury suit brought by some of that contractor's employees. The contractor had a service agreement with Exxon requiring it to obtain at least $2 million in CGL coverage that covered Exxon as an additional insured. The contractor procured that and more. They had a $4.5 million primary policy that did name Exxon as an additional insured. And they also had an umbrella policy, which is really the subject of the case. The underlying claims required well over $20 million to settle. And so Exxon wanted coverage under both policies, and the primary insurer agreed to cover them, but not the umbrella coverage. Exxon sued. They won in the trial court, but the Court of Appeals reversed it, saying they weren't covered under the umbrella policy. And the Texas Supreme Court took that and held that no, they are covered by the umbrella policy. And what's notable about this case is the way the court analyzed the issue. Now, they reaffirmed the principle that insurance policies can incorporate a separate contract. And they didn't back off from that, but what they did say was that that's going to be viewed very narrowly. So they'll start with the policy in question, look at the reference to the contract, and they will only look to that other contract for the specific purpose for which it's referenced. So there were provisions in that contract that the insurance company could point to say, no, that you're not intended to be covered under this umbrella coverage. But the only reason the contract was referenced was to identify who was an insured under the umbrella policy. They found the answer to that. That was yes, Exxon was an insured and didn't care about the rest of the contract and concluded that Exxon had coverage under the $25 million umbrella policy. Now, a couple oil and gas cases. First one is Devon Energy versus Shepherd. This is a royalty dispute where the underlying lease provided for the landowner to get a percentage of the gross proceeds from production. Now, this concept of gross proceeds is well understood in the law. There are a lot of cases defining what that means and what the contours of it is. But this one had a little wrinkle in it. It had a provision that said that if any disposition, contract, or sale of oil or gas shall include any reduction or charge for the expenses or costs of production, treatment, transportation, manufacturing, processing, or marketing, then such deduction, expense, or cost shall be added to gross proceeds so that the lessor's royalty shall never be chargeable directly or indirectly with any costs or expenses. Now, the producer argued that gross proceeds can never be more than what their actual proceeds were, and you can't charge them for costs that they personally didn't deduct. But the trial court and the Court of Appeals said, no, that's wrong, and the Supreme Court agreed. And they said, they agreed, first of all, that yes, gross proceeds does have a well understood meaning, and it's whatever you receive upon the sale of the oil and gas without any deductions. But the parties are free to define the royalty however they like. And in this case, they unambiguously provided that it may exceed gross proceeds if your proceeds were arrived at by deducting post-production costs. So the lesson from this case is, yes, there's case law that can help interpret and understand oil and gas leases and deeds and the terms therein, but the court's always going to look to what the explicit language of the agreement is, and if it's different, it's going to depart from what those cases say. And the last one I was going to cover is Van Dyke versus Navigator Group. This is a case that involves the so-called double fraction dilemma, where a deed will convey a royalty interest or a mineral interest as a percentage of a percentage. And in this case, it dealt with a 1924 deed that conveyed the land and reserved 1/2 of 1/8 of the minerals. And the question is 1/2 of 1/8, is that 1/16, or is that 1/2 of all the minerals? Mathematically, the answer is clear. It's 1/16. The lower courts held that it was 1/16, and the Supreme Court said no, it's 1/2. And the way they got there was they said that in old deeds, it was so prevalent and so customary to refer to the minerals or the royalty right as 1/8. That 1/8 means the entire royalty or the entire mineral interest. And so when you convey 1/2 of 1/8 in that context, that's half the minerals. And this built on a prior decision from 2016, Highsaw versus Dawkins, where the question was, what's the royalty when it's defined as 1/3 of 1/8, and the court said it's 1/3, not 1/24, as it would be mathematically. because 1/8 was a reference to the entire royalty, whatever it was. Now, they said that was a term of art that was just commonplace at the time. And so what this case adds, what the Van Dyke case adds to Highsaw versus Dawkins, is it says that whenever a court encounters a deed like this that has a fraction of 1/8, there is a rebuttable presumption that arises that the 1/8 refers to the entire mineral interest or entire royalty interest. And unless that deed itself has other language in it that suggests that that's not the correct interpretation, that's the one that's going to prevail. So we've got a few other cases, but I think we're running short on time. If anyone has any questions, we'd be glad to hear those. Let's see. So I'm seeing in the chat that someone asked, is it true that the Supreme Court can reassign appeals to the 15th court under docket equalization? The answer to that is yes. They can send cases to the 15th Court of Appeals from any other Court of Appeals as docket equalization, but notably, they can't send cases that are within the 15th Court of Appeals jurisdiction to other courts of appeals. So that's a one-way right there. Another question was, has the business court statute been appealed as unconstitutional? To my knowledge, there's not been any litigation yet, but then these courts don't go into effect until September. So between now and then, I would imagine there'll be some kind of litigation that will go to the Supreme Court directly, because of the statute says that those cases are supposed to be brought directly to the Supreme Court. And are there any other questions? Well, if not, I'd like to take the opportunity to remind you that next month we've got another presentation where our own Ryan Cordell will be presenting about his recent experience trying cases and what he learned in that process. Ryan's right here in the room with us. So that's your presenter right there. That'll be on February 15th. And for this course today, it's good for 1 hour of credit. The course number is there on your screen. And we thank all of you all for coming. And we hope you have a terrific afternoon. Thank you.